How does my trust avoid probate? I'm Dan Covington. I'm an estate planning attorney. I help people get trust, powers of attorney together, wills, living wills. How does my trust avoid probate? Well, why is it that a will needs to be probated through months of administration through the court system, but my family can handle my trust without that kind of procedure? Well, a trust is a contract. First and foremost, so Kansas law has determined that trusts are enforceable agreements. Because they're enforceable agreements, trusts are valid methods to transfer assets presently and upon or after one's death. So how does this differ from a will? How does a will work? Well, your will, you've seen them or been familiar with them. It might say that you want everything to go to your spouse. It might go on to say that if your spouse doesn't survive you, then divide all of your assets among your children. So granted, it's going to contain more language than that, but that's the heart of the will. So with the will, when you pass away, your will's offered to the court for probate. Then once it's accepted and probate and approved by the court, then it can act on or control any property that you owned so long as it didn't already pass to someone else. And that's just to say that you're probably familiar with joint ownership, maybe a bank account or a vehicle or even real estate. You own it as a joint title with right of survivorship with someone else. So that means just upon proof of death, the other person's going to own the property outright. The survivor owns the property just by title. Your will is going to act on anything that's titled individually in your name, and it's not joint titled or somehow automatically passes, like maybe a life insurance policy that has a beneficiary. So now, once your will is offered and accepted for probate, it can direct the distribution of those assets that you owned individually. Your executor has to follow a procedure of administration with this, that once notice is given to creditors, heirs, devisees, legatees, your estate can then pay expensive administration and claims, and after that, then your executor can seek approval to distribute assets as your will directed. This is often a 6-month or more process. That's not unusual at all for probate to run at least that long. So how is a trust different? So again, a trust is a contract. It's a contract that you enter into with your trustee, the person who you are going to nominate to administer your trust. You convey property into your trust during life. So that's a big key difference right there. During your life, you convey ownership of your property. You still have control over it, but you convey ownership into the trust. So that's a key distinction legally, that the property is already passed into your trust. So a probate court doesn't need to say, we're going to take this out of the decedent's name and convey it on to devisees or legatees. So because your trust already owns the property in your trust doesn't need to be probated at your death to move it out of your hands and into an estate or to distributees, beneficiaries. Your trust is likely going to direct that your trustee pays some taxes and final expenses, funeral and things like that. Then it may direct that either your trustee manage for a time or distribute your property according to your directions in your trust. There are some notice and transparency requirements, but essentially your trustee has the authority to go ahead and distribute your assets per your wishes. It's important to note that your trustee is obligated to act only as directed in the trust document, without discretion to vary from the trust agreement. Your trustee is required to act per your trust. They don't just get to do what they think you wanted. So what really, as a practical matter, what really happens upon your death with the trust? Well, the trustee needs to take care of a few things without involving the court system. They, like I said, give notice to beneficiaries, take care of some final expenses and taxes. Then the trustee can, without any court request or approval, without court involvement really at all, distribute your assets. Again, these assets were already in the trust. Trustee has to distribute those as directed in the trust document, or they can be in a lot of trouble. The trustee might, depending on what kind of provisions you have in your trust, the trustee might manage some assets for a time. That might happen to certain people for certain reasons, like education. Maybe your trust has provided that some certain sum or percentage is set aside for your children or your grandchildren's post-high school education or training. Or maybe a lot of folks like to set up a trust that if a beneficiary is going to receive maybe a larger sum than they're used to, maybe they're going to receive it, a portion of it at age 21 or 22 or 25, or the remainder at 30 or 35 even. Once the trustee then has completed all those distributions, they terminate the trust, shut it down, and it's done. Again, it was all a private matter. The trustee was bound by the terms of the trust contract, but it didn't take a lot of time to process this through the courts, hire an attorney to do all those things and give all the notices and get court permissions and proceed correctly with all the probate administration. So just to wrap up, a trust is different because it doesn't require all this probate that the court set aside the assets for administration and distribution. The trust assets are already set aside into the trust, prepared for management and distribution. So I hope I've provided some clarity on this. That's kind of the case with all. I think I maybe have 20 videos or so out there at this point. The point is to educate you, because the last thing I want is for someone to come through my firm, sign an estate plan, be all done with it, and not really know what they have or what's going on or how it works. So again, I hope this helps you out. I'm Dan Covington. You can always find me on Facebook, on YouTube, or on the web at Estate Plan Kansas. Thank you.